morning, ladies and gentlemen of the jury. This is an opportunity for me to tell the world, the jurors around the globe, what is happening in the American courts. American courts are thought to be the best in the world, but you haven't seen the inner functioning of that court. Before I begin, before I attack anybody, I wanted to give you the facts of the case first. This is going to be David versus AT&T Part 8. Part 8. It's called Frivolous and Malicious. That's the subheading. Now, what I am going to show to you and to the civilized world around the globe is how the judicial system in America is functioning. We know all over the world the governments are corrupt. Everywhere you read newspapers, watch the television, you know what's going on all across the world. Okay? Israeli Prime Minister is in trouble. President Trump is in trouble right from the day he assumed office. Every world leader, we have problems. And so we have in America and the American courts. Now, before I go into the details, I want to tell you a few facts of the case. In 1974, I and my family of 3 girls and my wife, we migrated to the land of opportunities, to the United States. The very first day I got there, I got a job, although I had to wait for my social security number to begin employment. I worked for a company called Michigan Bell Telephone Company in Detroit, Michigan. After working there for nearly 6 months, I was summoned by my immediate boss and told me, Mr. David, we were watching you. We were very happy with your work. We want to promote you. He asked me my background because the immediate bosses, they don't get the personal file or information from the central personal department. I talked to him, I told him I used to work as a secretary in India. I also happened to work for the Chief Justice of India for a short time at his home. In England, I worked for the British Post Office, where I had received 2 commendations and cash awards from the British government for catching some crooked people who were printing pension books and bank books to collect money. Eventually we moved to America, and as I said, I started working for Michigan Bell, and I explained to my boss my background. He said, would you like to be considered for a secretarial position, which is management? I said, yes sir. He sent me for a test. I passed the test in flying colors, and the central personnel sent me to work for a gentleman by the name David Bartz, B-A-R-T-C. I'm sure he would have been dead by now, but I went to work for him. He said, no, I don't want a male as my secretary. That's the first reaction from the guy. But the central personnel insisted that he takes me, so I worked for this guy for a period of 3 or 4 days. Then he said, I am not fit to do his job. He let me go back to the department I was working previously, and I was reluctantly forced to file a EEOC complaint, Equal Employment Opportunity Commission complaint, created by the US Congress. That commission came and investigated the matter, found the employer guilty of sex discrimination, and ordered them to pay me compensation and reinstatement. I thereafter went to work for 4 different people. One is a German, Richard Riemann Schneider. Second one, Delsley, is a French. Third one, Bob Cooper, who is an American black. And Hank Hodgson, who is an American white. All of these people found me way overqualified. Mr. Hank Hodgson, the white guy, recommended that I take a management assessment program which lasted 3 days, at which I got a perfect score, 100 out of 100, or 10, whatever it is, 10 out of 10 areas they examine you, I got full score. They were supposed to send me, after the result is over, 3 years management training. They call intensive management training, which they refused as a retaliation for filing the previous sex discrimination case. I was forced to file a second charge of retaliation, and before the EEOC commenced the investigation, Michigan Bell settled the matter and sent me to work for its then parent company known as American Telephone and Telegraph Company, or in short, AT&T. I was interviewed. They hired me and told me to start on April 1st, 1979 in Orlando, Florida, where AT&T had their monopolist division defending against the U.S. Department of Justice and various other entities who were charging AT&T for violation of the Anti-Sherman Act. I worked there. I continued to receive every 6 months a pay raise because I was a junior. So they gave me every 6 months a merit increase. On or about August 1981, AT&T and the U.S. Department of Justice announced the breakup of AT&T from the telephone companies. They wanted to break these companies into separate segments, each competing against the other. We were told at the time by the management we will be given 3 years' salary as compensation and other benefits such as my ERISA benefits, my pension, retirement. This is the open announcement at a public meeting. But in my case, the AT&T or Michigan Bell didn't give me any of the benefits to which I was entitled to. They offered me $35,000. I said I don't want the money. Then they said, Mr. David, come tomorrow for another meeting with your wife. And then I went there. They said, we will give you $45,000. You want to take it or leave it? We said, we don't want the money. Then I was summarily, without any cause, fired in the invited presence of my wife. That's the end of the matter. AT&T held me to economic ransom and blackmail. AT&T may look like the best company in the world, or they make people to feel that way. That is one of the sucker companies I've ever seen in my life. They say the barbarians in the Middle East and the Saudi and Kuwait, Oman, but they give their employees their due share, their benefits. But this sucker company doesn't want to give me anything. They literally held me to economic ransom. At the time, my youngest child, who is a doctor today, he was 3 years old. My other daughters were 7, 9, 11. I had my dependent father. My wife was taking care of the children. So I am the sole breadwinner. They held literally the whole family to economic ransom, failing to fulfill the terms of their agreement. Eventually, I was forced to sign a certain release. Under extreme duress, coercion, and through fraud, because I had no means to feed my small children and dependent father. Subsequently, I filed a third EEOC complaint, telling the EEOC I was discriminated because of my age, because I was then over the age of 40. I was also discriminated by firing me without a just cause. On Monday that week, AT&T had given me $5,000 merit increase and a fully satisfactory job performance rating. 3 days later, I am fired. For what? No legal basis. I filed the lawsuit in Orlando District Court in Florida. The judge assigned to the case was John A. Reed Jr. You will see his picture. The defendants, AT&T and Michigan Bell, brought in what is called a motion to dismiss the case. They want to have the case dismissed, alleging Mr. David has signed a release waiving his claims. The judge said, "Hi guys, I can't dismiss the case. I am going to go by what the US Supreme Court said in Alexander versus Gardner-Denver. In the Alexander Gardner-Denver case, the Supreme Court drew the party's attention to footnote 15 of the case. The footnote 15 states that an employer can obtain a release from an employee provided A, the release is signed by the employee freely, voluntarily, and knowingly, a three-pronged test. Here, the burden is upon AT&T to prove I quit the job. Not they fired me, I quit the job. That is what is stated in the release. What is true? Did I quit the job, leaving my 3 children? Or they fired me? The additional burden is I went in front of AT&T, demonstrated, picketed there along with my children and my father. It's on prime time television, which says the little David's fight against the mighty Goliath. Folks, under the law, the burden, the preliminary burden, is upon the employer, not the employee. They have to prove I quit the job freely, voluntarily, and knowingly. I had demanded in my complaint a demand for a jury trial. Jury trial means, those who are not familiar, in America, if the amount in controversy between the parties is over $20, you have the right to demand a jury trial. So it will not be left to the discretion of the judge. It is for the jury to decide factual issues. AT&T doesn't want this. Neither they want a trial nor a jury trial. Folks, the judge, I thought was honorable. That was his good ruling. But AT&T doesn't want to settle the case, admitting what they did is wrong, but they deployed other tactics to beat the little guy. One of the tactics they deployed was secretly hire the judge's former law clerk, a close friend of the judge, without disclosing their relationship. That woman's name is Ann C. Conway. Who was subsequently made the judge at the same court. Then she was made the chief judge. Then when I started putting out stuff on the YouTube and the Facebook, they immediately moved her to the US government's surveillance court in DC, where she is now one of the judges. So what happened was, folks, this judge was meeting this woman at her home. This woman was meeting the judge at his home, which is a serious violation of the canons of ethics. A judge meeting my opposite party's counsel at her home, and she is meeting him at his home, and they were meeting each other at different places. What is the reason why? Do they have something to cover up? Folks, it didn't take much long for me to discover. I started my discoveries not knowing at the time there is some hanky-panky going on. I sent the judge a questionnaire, 20 questions. As soon as the judge got the questionnaire, he picked up the phone and called me to my place in Yonkers, New York. A sitting federal judge calling a non-attorney litigant to his home. Have you heard of that? A judge cannot even call a lawyer to his home. This judge calls me. He says, Mr. David, I'm not going to answer your questions in writing, but I will give you answers over the phone. You understand, folks? A sitting federal judge, John Reed, you see him here, he is calling me to tell Mr. David, I was meeting this woman who is now the defendant's lawyer at that time, although she is now a judge in the US surveillance court judge. So they were meeting, scheming, planning how to avoid a trial. The Federal Rules of Civil Procedure, Rule 1 says, a judge should conduct the proceedings speedily, expeditiously, with the minimal cost to the parties. But folks, in this case, since 1982, until the judge resigned and left the bench in 1985, he did absolutely nothing. Absolutely nothing. To cover up their relationship, this judge will say, Mr. David, come into my private room, not in the open court. He doesn't want the public to know what's going on here. Folks, this is a serious matter. Serious violation of the canons of ethics. This is not something I made up. This is all in the federal record. Okay? So the judge first issued an order denying the defendant's motion to dismiss, which you will see here. In the order, the court said it will conduct an evidentiary hearing to determine whether the release is valid or not, pursuant to the standards set by the court in Alexander versus Denver Gardner. Did he conduct a trial? No, folks. From 1982, 83, 84, 85, the judge did absolutely nothing, which is a violation of Rule 1 of the Federal Rules of Civil Procedure. Then, when the judge made the disclosure, the startling disclosure, that he was meeting this woman at her home and vice versa, and other places, he was also shareholder of this company. He had worked for a subsidiary of this company before he became a judge. When all this debt was disclosed, I notified the FBI. and also the Chief Justice, Honorable Warren Burger at the U.S. Supreme Court. Within a week or so, Judge Reed recused from the case. You will see a copy of his. The recusal didn't say why he is stepping down, but the world understands. When a judge is dealing directly with the opposite party's lawyer at her home and other places, anything can happen. At the time in 1982, federal judges made $73,000 a year. Okay, which is $1,500 a week. Okay, so the judges have the incentives to get a kickback or money under the table because they have to live with the decency and dignity, and the income from the job as a judge is inadequate. I have no proof the judge collected money from AT&T or through the woman, but you can guess why a federal judge who has sworn to uphold the law, interpret and apply the laws, failed to do so in 4 years. 82, 83, 84, 85, 5 years. Okay, what was he doing? What is Rule 1 of the Federal Rules of Civil Procedure? The defendants, in the meantime, tried to get what is called a fishing expedition to prove I quit the job. They want to depose me and my wife for 3 full days questioning us. They couldn't get a damn. I didn't quit the job, I was fired. My wife is a witness, eyewitness, because I was fired in her invited presence. What will normally lawyers do? When they can't prove their case, they have to either suffer the humiliation and settle it, or prolong the agony, thinking that they can discourage a person like me fighting the case. That's why I'm fighting 36 years this damn case. I was given absolutely no discovery. I was watching a Federal Judicial Center video by Paul W. Grimm. He talks about mandatory initial the IDA program, pilot program, which speaks about the discovery procedure mainly. But in my case, no discovery whatsoever. It is like going to a war, the other party is coming with a nuclear bomb, I don't even have a gun. You understand the gimmicks here? If it is a fair trial, the judge should have conducted a hearing to determine whether the release is valid or not. If it is not valid, then you should move to the next procedure, which is asking the jury the questions of fact for them to answer. Did I quit the job voluntarily, freely and knowingly? Was I fired illegally in violation of the laws? I sued the company at the time for Age Discrimination in Employment Act, which is called ADEA, and also Title 7 of the Civil Rights Act. So, subsequently I added what is called ERISA, Employees Retirement Income Security Act claims. The judge resigned from the bench to the surprise of the world, which the judge doesn't, the superior courts don't want to hear all these things because that is the dirtiest business. They don't want to see their brethren being suffered humiliation. So, the Supreme Court found later on my claims against this company frivolous and malicious. Folks, we are not going to the main attack, the legal attack. Mr. Pete Sinaba, who is the lead counsel for AT&T, who was then employed at a law firm called Carlton Field, Emanuel, Cutler and Smith of Tampa. He deployed another tactics. Now, before I'm going to tell you how he deployed the tactics. After Judge Reed recused from the case, they assigned the case to another judge in another town. Although the Federal District Court in Orlando at that time had as many as 6 judges, all of them are qualified to conduct a simple evidentiary hearing. But they don't want that. They don't want that held there in Orlando. So this case was reassigned by Judge Reed to William Terrell Hodges. Judge Hodges issues me an order. Mr. David, come before me from New York to Tampa because I am the chief judge. This case has been assigned to me. Folks, how can I go to Tampa when none of the parties were present there? None of the parties had jurisdiction in Tampa. I didn't live in Tampa. I had nothing to do with the cause of action that arose in Orlando. But this judge said, Mr. David, come down to my court in Tampa. He issued me an order. It's a court's order. I flew into Tampa. The meeting was conducted in the presence of security personnel, FBI agents, local police, sheriffs, as if I am a wanted criminal appearing in a criminal court. This is a civil case. I did not even have a parking ticket. I'm not a wanted person. I'm fighting a case based on the laws passed by the US Congress. Folks, this judge said, Mr. David, your motion to transfer the case to New York is denied. I am the chief judge. I am going to conduct these proceedings in this court. So he left. Nothing happened, people, ladies and gentlemen. Neither the first judge, John Reed, did anything, nor this judge. They made another deal under the table with these companies. Sold deals under the table. So the judge was told, don't conduct any hearing and trial. We are doing something sinister. So what AT&T did was, and Michigan Bell, they fired yet another employee. His name is Orville E. McDonald. Mr. McDonald, as per report, was a division manager working for AT&T in New Jersey. They gave him $12,000 and fired him. Mr. McDonald moved to the state court as opposed to the federal court, alleging violation of the Title VII, EEO, whatever it is. I haven't even seen a copy of his complaint, nor a copy of the court's decision. As soon as this Michigan State Court renders a per curiam unpublished order telling McDonald must tender back the consideration to the employer, Michigan Bell obtains a copy of the same day it was rendered and moves Judge Hodges to dismiss my claims based on a subsequently procured judgment. You understand? No trial needed, no hearing needed with regard to the validity of the release. The issue changed from whether the release is valid or not to tender back to the Michigan Bell the consideration they paid me. Folks, in Aubrey versus Energy, the U.S. Supreme Court said clearly a Title VII and ADA claimant need not return the consideration back to the employer in the first place. He can continue litigation without tendering back the consideration. But who cares about what Supreme Court says? Supreme Court has said so many things. The district judges, they violate the laws. They don't care a rule 1 of the Federal Rules of Civil Procedure or discovery process. They just wing because they don't want to give any damaging information. I was denied discovery during the last 36 years. Does this company have any merit to their claims? No, folks. What they deployed was, as soon as the Michigan State Court rendered its per curiam unpublished order and opinion, this judge takes his hat, makes his findings of facts and conclusions of law from his hat. Because I never met the judge. I never met the judge except for the first initial conference. How can a judge, a federal judge, make findings of facts and conclusions of law without giving me an opportunity to file opposition to the motion? No way. The judge never spoke to me, never scheduled me for another hearing. As soon as this judge, this puppet judge, gets this Michigan State Court's order, he issues an order immediately. He directs the clerk, if Mr. David didn't tender back the consideration paid to him, dismiss the case without prejudice. Watch the word without prejudice. That's what the Judge Hodges does. How did he make the findings of facts and conclusions of law? Nobody knows. How can a judge make his findings? This SOB never met me, never had my papers filed, never had a hearing. Okay? He makes a findings of facts which says Mr. David left the employee. One of his judgments, Mr. David left the employee of Michigan. That's a factual issue for the jury to decide. Okay? How can a judge make a findings? You never appeared before him after the first conference. There was no pleadings, no arguments, nothing. AT&T files this paper, Michigan Court case law. The judge rubber stamps. Folks, when people commit crime, they always leave some clues. What the judge did was to order the dismissal of the case without prejudice. But they paid money under the table to the clerk of the court. So, this guy, Donald Brown, altered the judge's order as a dismissal on the merits. The judge says one thing, the clerk writes the opposite. Folks, I didn't know at the time the fraud. So, what Mr. Zinaber and Annie Conway And the lawyers for both these companies, their in-house counsels, they filed a false jurisdictional statement. Which says the United States Court of Appeal has jurisdiction pursuant to 28 U.S.C. 1291 to hear the case, because that jurisdictional statement was false. It was the clerk who twisted it. You understand? The judge says one thing, the clerk does the opposite, and based on that, they file an appeal jurisdictional statement. The United States Court of Appeals for the 11th Circuit has jurisdiction only if it is a final judgment on the merits, not an interlocutory order. Folks, under the scheme, in order to succeed in the scheme, you've got to have a lot of insiders working for you. So Mr. Zinavarani Conway pretend they didn't read Judge Hodges' order. They only read the clerk's entry of judgment dismissing the case as on the merits, which is not what the court ordered. You have to see the judge's order one, the clerk's entry of judgment. Now, the Federal Judicial Center, in one of their documentaries, I saw every Circuit Court of Appeal is required and mandated to see whether the appellate court has jurisdiction or not. So this guy, his name is Miguel Curtis. I never met him, but I later on learned from the records. He was the clerk of the court. He never examined whether the United States Court of Appeal has jurisdiction to hear the case. They close their eyes, they wink their eyes. You understand? The gimmick. Now, under the scheme, they got to have insiders working at the 11th Circuit Court of Appeals. There are a lot of honorable judges there, then and even now. But they don't get these files, these cases. These cases, this kind of case, goes to a particular panel, specially arranged. Folks, this case went to a panel of judges. One is called Robert Vance. Robert Vance was murdered, bombed and murdered in 1985 or 86. I don't have the exact date, we have to look. He was murdered. Somebody sent him a bomb in the mail. He opened up and he is gone. The second panel was called Clarence Allgood. He took a gun and shot and killed himself. United States Court of Appeal for the 11th Circuit judges who were in my panel. 2 judges gone. The third judge, J.L. Edmondson, the black guy. You can read in Google and other YouTube and presentation how he handled the corporation cases. He was one of their precious insider helping them. Okay? Now, based on this 3-judge panel who accepted the case in error and who affirmed Judge Hodges' order. It is not Judge Hodges' order, it is a clerk entry of judgment, which said they affirmed what they are affirming. You understand, folks? The judges have nothing to affirm. They have no jurisdiction to start with to hear the damn case. I was given 5 minutes time to argue. I went before that court, 11th Circuit Court of Appeals, 5 minutes time. At the time, folks, I didn't know the fraud going on here in the courts. The United States Court of Appeal is thought to be a court of justice. It's not a place where you can trade your wares for money. But well, that's what they did it. Okay? There are honorable judges then and even now in that court. But the case doesn't go to those panel members. It only goes to the panel who are thought to be corrupt. Otherwise, Judge once won't be murdered. The second judge won't take a gun and shoot and kill himself. There is problem which the United States courts, the Federal Judicial Center doesn't want the public to know. Okay? The case goes to the US Supreme Court in 1986. Supreme Court has a printing machine, as I told you before. They say certiorari denied. They don't care a damn. Ladies and gentlemen of the jury, I'm addressing the world community to render a decision. I didn't have the opportunity to present my case during the last 36 years before a court or a jurors. The jurors are supposed to render a judgment based on the merits, based on the laws passed by the Congress. But these companies, they don't want a jury trial that will expose them. So, what happened was, after the United States Court of Appeal for the 11th Circuit rendered a decision accepting jurisdiction and affirming without opinion, and the Supreme Court of the United States of America denying certiorari in 1986. 5 years later on, while working at a New York law firm, and after reading the law journal, I realized the difference between a dismissal without prejudice and a dismissal on the merits. In this case, what had happened was, Judge Hodges issued an order dismissing the case without prejudice if I didn't tender back the consideration back to the employer, which itself was overruled by the US Supreme Court in Aubrey versus End Energy. Judge Hodges, before Judge Hodges, I filed a motion asking the court to correct the error made by the clerk of the court, Donald Brown. Donald Brown is the deputy clerk who changed the court's order from a dismissal without prejudice into a dismissal on the merits. That's not what the court had ordered. Okay, you have to understand the gimmicks going on here. Judge Reed, after admitting he was meeting my opposite party's counsel, Miss Conway, at her home and at his place and other places, when he admits this in a taped telephone conversation, and when I reported him to the FBI and the former Chief Justice of the US Supreme Court, Honorable Warren Burger, Judge resigns from the bench after accusing himself. Why? The judge was doing the hangy-pangy in violation of the canons of ethics. You can't go to the opposite party's counsel's home and vice versa. So they were making a deal. This woman, Nancy Conway, who was then a counsel, a private attorney, she was meeting the judge at his home. at his home, her home, and in Atlanta, which the judge admitted. Oh, now, when I filed the motion before Judge Hodges, telling him under Rule 60B of the Federal Rules of Civil Procedure, the clerk had made, I don't think it's an error, it's an intentional error done by the court, by the clerk of the court, at the instance of the defendants. The defendants knew, they read the Judge Hodges' 5-page order dismissing the case as without prejudice. The clerk alters, okay? Clerk alters on his own. Now, Judge Hodges says, yeah, the clerk made a mistake, a clerical error under Rule 59 of the Federal Rules of Civil Procedure. I am directing the clerk to amend the judgment. The first clerk, Donald Brown, was dismissed by the court at the instance of 2 judges who were told he is doing this all the time. So Judge Patricia Fassett and another judge, they reported him as incompetent. So he was fired from the court. You see a copy of the Sentinel article about him. Now the new clerk enters a judgment as without prejudice. What is the effect of this new judgment? The Court of Appeals for the 11th Circuit accepted jurisdiction to begin with. They accepted and affirmed, and the US Supreme Court denied cert. Now, 5 years after, Judge Hodges says, hey, we made a mistake, guys. They all know this. They are all in cahoots with. If the judge had issued, as he did, an interlocutory order dismissing the case as without prejudice, he should have continued with the action. He cannot just issue an interlocutory order and forget about it. It's all under the deal. Now he enters a new judgment. He orders the clerk to enter a judgment dismissing the case as without prejudice. Retrospective effect from the date of the original entry of judgment in 1985. Okay? Now, the 11th Circuit Court of Appeal had no jurisdiction to consider and affirm an interlocutory order, which is what they did. They are required, the clerk of the court is required to independently determine whether the 11th Circuit Court of Appeal has jurisdiction to consider the matter. So it's all under a scheme, well-orchestrated scheme going on within the court system. The clerk of the court, the deputy clerk, the routing clerk, and which panel they wanted, pick and choose, guys. We have this panel, this is what you wanted? Yes, sir. Oh, we don't want such and such a judge, we only want certain judges. So the panel of the 11th Circuit, headed by Robert Vance, Clarence Allgood, and J.L. Edmondson, affirm what? The same shit. which the clerk did. Now, I moved to the 11th Circuit Court of Appeals, asking that court to recall mandates. When they issued a mandate, an error, I am asking the court, you guys have no jurisdiction. This was all done through the insiders, the clerk of the court in Tampa altering the court's order, and the clerk of the 11th Circuit, without examining whether it has jurisdiction or not, accepting the case and placing it before the panel. So you made a mistake. Judge Edmondson was the only judge who is alive today. The first panel members, Robert Vance, was murdered, bombed and murdered by one Mr. Moody. I tried to contact him, they won't let me speak to him, or they won't allow him to respond to my letters to find out why he sent the bomb to kill the judge. They won't let. I tried to contact him in the federal penitentiary in Florida, in Alabama. They won't let him talk to me because he's a prisoner who is subject to be hanged or executed. It is being stayed. So, Judge Edmondson is the only one. Judge Edmondson, pursuant to the 11th Circuit Court of Appeal rules, retired effective 2012. Okay, folks, the scheme here, I'm trying to expose that scheme. Anything you file in the court, it goes to a select routing clerk. You understand this? The name of the game? It goes only to Edmondson. Although there are a panel of so many judges in that circuit. Honorable, who will interpret and apply the laws based on the laws passed by the Congress. But there are also crooked judges, and they know who they are. The defendants, they are not dealing one day with one judge and a different judge. They know the history of every judge. That is what we were doing when we were in Orlando. They tried to get the entire biography of the judges, which political party he or she came from, whom to bribe, how to fix cases. They don't win cases on the merits, never ever. That is AT&T's tactics. So this case goes back to Edmondson, J.L. Edmondson. He is one of the members of the original panel who accepted jurisdiction. How can you ask the same judge who made a mistake to review his own judgment? He refused. He refused. He ordered the clerk of the court not to accept any papers from Mr. David based on this closed file. They closed the file. That's what Judge Edmondson says. Folks, before I moved to the 11th Circuit Court of Appeal, something happened. I moved to New York in 1982 from Florida after a painful divorce. My family life was broken as a result of this defendant's tactics, barbaric tactics. They don't care a damn about the family life. The Arabs and the Saudis and the Dubai people, they respect their employees. They live by their words. They give them the benefits due to them. But this sucker company, who pays $74 million to its president as retirement benefits, they don't want to give me a dime for the years I worked for them. They don't want to admit they made a mistake. They schemed. They spent more than $30 million according to my best calculation, not under the table on the books. Well, how much they paid to the judges, we don't know, because Annie Conway goes to the judge with her briefcase and she says, "Judge, we have here, you can't leave $1,403 a week from your federal judge job." So judge takes it. I have no proof, you can guess. The federal judges in 1982 made $72,000 a year. Which, when translated into hourly or yearly, weekly basis, comes to $1,403. Can a federal judge live on that? So the defendants managed everything because they don't want to settle it with me for millions. They can pay part of the money to the judges, the players, the insiders, the clerk of the court. Okay? The clerk of the court in Tampa, the clerk of the court in Atlanta. At that time, a gentleman by the name Miguel Curtis was the clerk of the court. How they managed to get the panel? It's a top secret, state secret. They don't want the public to know how the scheme of assigning the cases to a panel takes place. It's a secret process. Of the list you have, they know which judge or judges should get the case, so they can easily get it affirmed. You understand the name of the game? Now folks, I waited so many years thinking Judge Hodges, who issued an amended order in 1991 admitting the clerk made a mistake, will conduct a proceedings pursuant to the rules. A judge cannot simply sit and say, "I issued a temporary order, that's the end of the matter, forget guys." Sort of well-orchestrated plan with this judge. After Judge Reed was forced to recuse and resign from the bench in disgrace. So this is part of the scheme. Judge Hodges won't do anything. I filed in 2006 another action against the sucker companies, AT&T and Michigan Bell, at the Eastern District of New York, seeking my ERISA benefits. ERISA means Employees Retirement Income Security Act, passed by the Congress. And this sucker company had amended the rules immediately after my termination to bestow the benefits upon the employee, provided he worked for 5 years or more. I worked 8 years. So I'm entitled. I had an agreement to work for this sucker company for 5 years, from 1979 until 1984. Fire and continued during the period of my employment, contracted employment. I would have completed easily 10 years of service. I was not fired for any reason. My failure to accept a sum of money offered to me to voluntarily quit. Did I quit, or did I sign a release and then leave the employment of the company? Which they don't want to answer. They know. They fired me. They conducted 3 days of fishing expedition of my deposition and that of my former wife, who is still alive in Lady Lake, Florida. They questioned me and her 3 days, 3 full days, trying to prove their burden. I quit the job. Did I quit the job, folks? A man with 4 small children, his dependent father and wife, she is not working. The dependent father came from India to be with us for a period. Do you think somebody with a family responsibility, mortgage to pay, car payments to pay, quit the job? That's a simple question for the jurist to reach the conclusion. So this sucker company doesn't want me jury trial, no discovery at all, Mr. David. Now, I filed the new action, which is 063199, before the Eastern District of New York. Judge Seibert, Joanna Seibert, gets the case. She is a Bill Clinton appointed judge. She's a Democrat. You understand? So, what the defendant now does is seek out the chairman of the Democratic Party's Rules Committee, Ralph Curtis Dawson, of the law firm of Fulbright and Jaworski, known then as such, and later on became Norton Rose, Fulbright and Jaworski, the chairman of the Democratic Party. Oh, Mr. Dawson has another scheme. All are schemers, fraudsters. They claim to be high-ranking officials, went to Columbia, Yale, Harvard. So whatever they say, that's the gospel truth. What an aggrieved pro se plaintiff says, we are all garbage. You have to understand, folks, you are the civilized people in America and all around the globe. You got to listen, you have to understand. Use your common sense, folks. Now, Mr. Dawson, Ralph Curtis Dawson, the black monkey, who is a Columbia and Yale graduate, he says to AT&T guys, don't worry, we have a scheme. Oh, what is the scheme? Mr. Dawson calls his newly engaged lawyer by the name Brian Wayne Tilker. He asked Mr. Tilker was licensed in 2005, I believe. He prepares an affidavit. He is the co-counsel with Ralph Curtis Dawson. So he prepares a sworn affidavit in flagrant violation of the canons of ethics. Because lawyer cannot testify as a witness and file his papers in the court. The brief filed is signed by Brian Wayne Tilker. And he is also testifying as a witness. No problem. Let's assume for the sake of argument, no problem. You say, although it's a violation, a flagrant violation of the canons. Now, what Tilker says in his sworn affidavit, on August 25, 1981, Mr. David signed a release in Michigan, Detroit. And that release, about which Tilker has personal knowledge. He says he has personal knowledge. Folks, Tilker also says how the defendants managed to get a judgment from the Taba court based on the merit. Understand? Based on the merit, they got a judgment which was affirmed by the US Supreme Court in 1985-86. So, Tilker submits this affidavit. This woman, Joanna Seibert, is the craziest woman I ever seen in my life. She grants a summary judgment to the defendants, citing Tilker's affidavit at least at 12 places. this is the basis for granting a summary judgment to the defendants, although the US Supreme Court says no summary judgment can be granted if there are tribal issues of material facts remaining. That's the Supreme Court's ruling in 1986 in the trilogy of the cases, 3 cases. No summary judgment can be granted. But he says, hell with the Supreme Court, who cares? I get paid from my company, AT&T and Michigan Bell and others, so I don't care. I can flagrantly violate all the laws passed by the Congress and the Supreme Court of the United States. See, she had the case for 7 years. 7 years. Not a single day, neither Tilker nor his boss, Ralph Curtis Dawson, came to the court. Not even a single day. I never seen them face to face. Okay? A counsel who represented AT&T never came to court in 7 years. And this threat grants a summary judgment based on Tilker's affidavit. That's the sole basis for granting a summary judgment in an ADEA, Title VII, and there is a claims. Folks, there is no provision at all in the Federal Rules of Civil Procedure, Federal Rules of Appeal Procedure, in the US Supreme Court case laws to grant a summary judgment to a losing party. Now, folks, I didn't rest there. I started my investigation about Tilker. According to the Unified Court System, New York, Tilker was born on May 5, 1979. Folks, listen, May 5, 1979, this sucker Tilker was born. So when I signed the release on August 25, 1981, how old this sucker was? 2 years old. Folks, listen, 2-year-old child testifying, who is an attorney now, he says he has personal knowledge. Myself executing a release in Detroit, Michigan, which is 665 miles away from New York. You understand? 2-year-old Tilker testifying. And this bitch, this SOB, she says summary judgment granted based on Tilker's affidavit. Do you grant a summary judgment in a Title VII, ADA, and ERISA claims solely and only on the basis of a 2-year-old child's affidavit? Folks, I deny. I was unemployed at the time, as I was many times, because what happens is, most of these big companies, when you fight against them, they try to blacklist you. Okay, folks, you have to understand this. During the 7 years I lived in Florida, I did not even have a parking ticket. I'm not a criminal wanted by anybody. Folks, that's my record. Okay, now the scheme is at the Second Circuit Court of Appeals. They have to do likewise. When I am questioning how a summary judgment can be granted based on a 2-year-old person's affidavit, the Second Circuit should have some answers. The judgment affirming showed no issue raised. They simply rubber stamped. Folks, Judge Walker, who is a nephew of Bush, I believe, he went to AT&T premises subsequently, going through a dirt road to Connecticut. Why did he go there? Maybe he wants to get this full, okay, the US dollar. So the guy who was guarding the premises, he stopped him. So he hit him and killed him. Judge Walker. Watch what the press and media says. Is the judge above the law? What is people? You are civilized people. Rina Ragi, another judge, and Judge Rakoff, 3-panel judge, affirmed what they are affirming. 2-year-old Tilker's affidavit, upon which this bitch granted a summary judgment to the defendants. Folks, the Supreme Court, as I told you before, they have a printing machine, and they have certain select law analysts, legal analysts sitting there. So all the major corporation cases go as a matter of routine to that clerk. One of them is called Melissa Blalock. She is one of their undercover agents working in the US Supreme Court. People don't know. The seniors, the 84-year-old judges, 82-year-old Justice Kennedy, and then 81-year-old all the justices are all senior people. They don't know what the hell going on. They have 10,000 cases in a year, 666 cases a month. Are they going to read the pleading, the responsive pleading, the motions, cross motions? They can't even read one or two and decide. So they leave the task of telling the court which case has merit. You understand the scheme in the Supreme Court of the United States? They don't read, justices don't read, they don't have the time. You understand? So, my case goes to a woman by the name Melissa Blalock, at least from the year 2010 onwards. Every time I file, it goes to her. You understand the scheme? The Supreme Court rules, and when I read the Federal Judicial Center materials, they say the Supreme Court selects highly qualified fresh graduates from the well-known universities. Melissa Blalock, I get no information about her. I tried to Google it. There are so many Melissa Blalock, so I don't know which one is which. The one I closely researched found out she was working for Coca-Cola company as a legal person. So she may be the one. I tried to Google her, tried to get her from the Facebook. I can't get her. She denies my petition. She doesn't do it. She advised the court. This case has no merit. So the Supreme Court denies it again. Okay? Now, to add insult to injury, this woman tells the justices that Mr. David is a litigator. He files frivolous appeals and malicious pleadings. Folks, you got to remember, frivolous means silly. It's not worthy of credence. The appeals that I filed in this case, David versus AT&T, first was for denial of a jury trial. The Constitution says if the amount in controversy is over $20, you have the right to demand a jury trial. AT&T says no. I said I want discovery. Discovery means the weapon by which you attack the other. AT&T deposed me 3 days. They couldn't get a damn to prove the release is valid. So the scheme with Miss Conway and Mr. Pete Sinova, their chief gladiator. These are the two who filed false papers. Sinova is an attorney licensed to practice law before the US Supreme Court. So is Miss Conway, and the defendant's in-house counsel, Mr. Hurst, and then I can't remember the other guy, they filed a false paper saying that the US Court of Appeal for the 11th Circuit has jurisdiction. Does it have jurisdiction? No, folks. It was halted by the clerk of the court, Donald Brown. His name is Donald Brown. So, it is not an isolated case where mistakes are taking place. Everything is interwoven tricks. Okay? Tricks and tactics. So, folks, the Supreme Court of the United States again denies my petition for writ of certiorari after the New York Second Circuit affirms Judge Seibert's order based on Tilker's false affidavit. What they are supposed to do is the Supreme Court independently find out what Tilker did was unethical, and there is no provision in the Federal Rules of Civil Procedure or the decision of the Supreme Court. No summary judgment can be granted when there are tribal issues of material facts remaining. Judge Reed of Orlando, before his recusal and resignation, had already ruled that there is a tribal issue of material fact remain in this case. What about his ruling? Gone with the wind. So the Seibert Court, based on Tilker's false and perjured attorney affidavit, grants a summary judgment. The Second Circuit Court of Appeals, without even reading my brief in opposition, without reading my brief and opposition papers, simply affirmed like the 11th Circuit did, and our wonderful Supreme Court denies certiorari based on Melissa Blaylock's advice to the court. My case is frivolous. Folks, that's the second denial of certiorari by the US Supreme Court. Did any of the justices, 9 of them or 8 of them at the time, did they read any of my brief or their respective law clerks? No, folks. That's the way the American Supreme Court functions. So you can understand what goes below it, 3 layers below it, and the district courts. It is purely a political court system. Folks, I didn't stop there. I filed another petition before the 11th Circuit Court of Appeals seeking vacatur of its mandate. The court had issued a mandate in 86, based on the false entry of judgment made by Donald Brown, who had altered the court's order from a dismissal without prejudice into a dismissal on the merits solely for the purpose of getting the foot at the 11th Circuit Court of Appeals to review the case when it had no jurisdiction. So this time I filed another brief before the court, the 11th Circuit. This, under the system, the routing system, all fraud, the routing clerk automatically assigned this case to Judge Edmondson. There are so many judges in the circuit. In my motion, I had asked the court for an en banc consideration. En banc means the entire court to review these papers. Judge Edmondson says, hell with the en banc court. I have the authority to rule because it's assigned to me. According to the 11th Circuit Court of 11th Circuit Court of Appeal regulations, internal operating procedure, when a judge ceases to be an active judge, he can't take part. And secondly, when a motion is made to a 3-judge panel or an en banc court, it should be heard either by a 3-judge panel pursuant to the Federal Rules of Civil Appellate Procedure, or by the en banc court, the entire court. Edmondson says, no, this is a closed case. I am directing the clerk not to accept any papers from Mr. David. Understand, a judge has no jurisdiction, no legal authority in 2012 onwards. He ceased to be a senior, he ceased to be a judge. He is a senior judge. He has no legal authority, but the case goes automatically through the routing clerk to him only. He says, Mr. Clerk, you can't accept any more papers from this sucker, David. He is a pain in the ass for us. So he directs the clerk of the court not to accept any papers from Mr. David. Folks, you have to listen. This is what he says. Don't accept any papers on this closed file. Okay? Despite Judge Edmondson's orders to the clerk of the court not to accept any papers, I filed 15 sets of brief, again citing the reason why the case merit consideration by the en banc court. Citing the rules. Folks, this time, this goes to Judge Edmondson and Stanley Marcus, who was a district judge in Miami, who issued a summary judgment against me, which was overruled by the same circuit, 11th Circuit Court of Appeal. He is now sitting as a judge in the 11th Circuit Court of Appeal. He says, Mr. David's appeal is denied. So, Mr. Stanley Marcus and Judge Edmondson, without even a 3-judge panel, denies what I am asking the court to do: vacate its mandate issued in 1986, because that court, the appellate court, had no jurisdiction. And secondly, the same judge who issued the order says we made a mistake. Judge Edmondson had no authority on his own to deny my motion, in which I sought an en banc hearing. Neither Judge Edmondson nor Marcus wanted to have this case heard or looked into by a 3-judge panel. Folks, I moved again to the Supreme Court, telling the US Supreme Court, look, the court below had no jurisdiction to start with. It was all done under the table with the clerk of the court. So this woman, Melissa Plowler, comes again. It never goes to anybody else. It goes to the identical panel in the lower court, in the Court of Appeals, and the Supreme Court. So this woman tells the justices, this case is malicious and frivolous, and we deny him the motion to proceed in forma pauperis. What is in forma pauperis is, if you make X amount of money, which is considered below the poverty level in America, you have the right to proceed to the appellate court without paying the court fee. Folks, this woman send my brief, Melissa Blaylock, sends my brief back to India. Costing the American taxpayer $100.05 to return. The reason is I failed to attach a one-page document known as a pre-printed form called Motion to Proceed in Forma Pauperis. She could have picked up the phone on my toll-free number here, sitting here. She can call me on my toll-free number from USA to India, free. It doesn't cost the American taxpayer not even a dime to get this one-page motion to proceed in forma pauperis. Or that she has to pick up the phone, dial my 631 area code 841-6222, which is clearly printed on the face of my appeal papers, where every attorney is required to fill in their section, the name and address and the phone number, which is there. So, Melissa Blaylock, their plant is owned by corporations. She sent my entire brief back to me to India. See the box. This is what she does. She sent the stuff back to me to India, saying that, Mr. David, you failed to attach this one-page document, so you redo it, send it back to us. It cost me, for people, a fortune, especially when you are living on a limited income abroad. So I have to take that thing off and then put another page and then repack and send it back to her with this one-page document. The Supreme Court says in its order, Mr. David's petition is frivolous and malicious. The Supreme Court don't read. It is not their decision. What they were led to believe by this bitch is my case is frivolous. Frivolous means silly. The US Supreme Court has ruled not once, so many occasions, as well as all the circuits, that when a court has no jurisdiction, its judgment is a nullity. Did the 11th Circuit Court of Appeal have jurisdiction to begin with? No, folks. It was altered by the clerk of the court, Donald Brown. Am I raising a silly question? No. It is a constitutionally important question for the justices to address. If I were a Jewish lawyer with a few names, with a feather on my hat, they would have said yes. Mr. David raised a question of constitutional importance. But Mr. David pro se, a non-attorney, raises the same question. They say frivolous. The issue that I am raising is frivolous. Who told the Supreme Court? This bitch, Melissa Blaylock, advised the court Mr. David is raising a frivolous issue. Also, the term used in the court's decision is Mr. David's appeal is frivolous and malicious. Understand, people? What is malicious means? They are saying something with malice. Is Judge Reed a part of the scheme along with Judge Hodges and Annie Conway, who is a federal judge today? This is not a malicious matter. It's a true matter. The scheme with this woman, Annie Conway, who was then a lawyer, She was subsequently made a judge in the same court because she trading the wares, how to fix cases. So they made a judge. The FBI gave her clearance without checking her credentials. Was she a felon? Yes, she was. She was colluding with a federal judge, going to his home, him going to her home, they are meeting in private, but they were acting in the color of the law. What is a judge and a law clerk and is an attorney? Is it malicious? Oh, the New York action. Is it malicious? Judge Seibert granting a summary judgment based on a 2-year-old Tilke's attorney affidavit. Violation of all the canons of ethics. There was an attorney by the name Christine Anderson, an attorney in the disciplinary committee of the New York Bar. She blew the whistle. They said the Bar Council is closing their eyes when prominent lawyers commit crimes. It was in the YouTube.
With the DDC. The DDC is a departmental disciplinary committee for which I used to work. I was a former principal attorney there for 6.5 years. I alleged that upon learning of the DDC's pattern and practice of whitewashing and routinely dismissing complaints leveled against certain select attorneys to the detriment of the public that the DDC is duty-bound to serve, I reported this wrongdoing pursuant to my rights under the First Amendment to the United States Constitution.
Okay. There was another professor who is a PhD. He does the same thing. He says the same thing. So the Bar Council looks the other way. What? Oh, we didn't hear. What is it? That's the name of the game going on in the American courts. Oh, the judge, the Supreme Court, on October 2nd, 2017, denies my motion to proceed again. And they cite, I'm going to show you, I'm going to show the video. The US Supreme Court on October 2, 2017 says in its order, the motion for leave to proceed in forma pauperis is denied and the petition for writ of mandamus is dismissed. Rule 39.8, period. As the petitioner has repeatedly abused this court's process, the clerk is directed not to accept any further petitions in non-criminal matters from petitioner unless the docketing fee required by Rule 38A is paid and the petition is submitted in compliance with Rule 33.1. He's also citing C. Martin versus District of Columbia Court of Appeals, 506 U.S. 1, 1992, per courier. That's the court's order on October 2, 2017. So, I, in compliance with that court's order, which says unless the sentence reads, unless petitioner is required to, unless the clerk is directed not to accept any petitions in non-criminal matters from petitioner, unless the docketing fee required by Rule 33A is paid and the petition is submitted. Folks, not that I can afford, because I live on a paltry social security pension abroad in India. So, I went to my bank, obtained a $300 check, which I'm going to show you here. I printed 40 sets of my brief. Okay, I'm going to show you the 40 sets of brief. And send it to the US Supreme Court, thinking the court will assign a case number and take the fee. Folks, this bitch, Melissa Brolock, she doesn't read what is written in the court's order. She sent that paper, the brief, and my check back to me to India. Okay? The court is telling, unless you pay the fee and the brief is filed, she sent the thing back to me again, costing the American taxpayer more money, more than the cost of the appeal itself. Okay? She sent everything back to me. When I went through the papers, which I'm going to show you, she says the petition is returned. What rules she's talking about? The US Supreme Court says you can have only X number of pages, should be used by the courier or the font size, the details are all in the rules. I comply with all the rules. It cost me a fortune. I sent them in 2 separate packs because Indian postal authorities don't allow you beyond certain weight limit. So I put 37 sets of brief in the original box with the draft, the $300 US dollar draft, made payable to the clerk of the court. What the clerk of the court is required to do: accept the papers, assign a case number. But this slut again, returning it back to me. She is the only clerk in the court, in the US Supreme Court. She has a supervisor by the name Jeff Atkinson. When I try to talk to him so many times, he won't even pick up the phone. It goes into a voicemail. He never returns the call. So this woman, a corporate plant, is working all her own with nobody supervising her. She can do whatever she wants. This is the Supreme Court we have. I immediately sent a letter to Judge John Roberts with the original check and page first of the brief, stamped on January 18th, back to him, asking him to investigate why this woman is sending my brief back to me. Folks, that was a long time ago. Today is March 6, 2018. I have no time to fight. I did everything humanly possible. The Supreme Court don't care. Or it is closing their eyes because major corporation is in trouble. The entire corrupt system is on challenge. Nobody wants to hear this. 36 years, no discovery, no hearing, no trial. Case moved from one kangaroo court to the other of the defendant's choice. Folks, this is a time for the American people as well as the civilized people around the globe to rise. Folks, decide, cast your vote. I'm going to make a movie which will be a hit. I want those who are producers, those who can help me financially, call me or write to me. My number from USA, area code 631-841-6222. My email address, trdavid2009@gmail.com. By the way, the panic button is there already. They are trying to prove Mr. David filed so many frivolous claims And one of them just surfaced yesterday when I looked at my Facebook. My case is there against an accounting firm, Appellate Company, where one of my co-workers was providing sexual favors to partners and other accountants. When I told her, do your job, don't pass it on to me, I was fired. And in the papers, the appeal court decision, they twisted the whole thing. I did have a fight with this young woman. She's a chain smoker. She takes 2-hour lunch break, 1-hour coffee break. He goes to entertain the partners, some of the partners, and some of the accountants. That's her job. She doesn't sit in her seat and do her job. Whatever work she gets, she passes it on to me. And I told her, so I was fired. And the next day, they said, you're not fired, you are laid off. Laid off. Next day, the same firm bring in 2 young girls, not one, to replace me, 2 young women. I filed a lawsuit. And we went for a jury trial. The judge was adamant, Judge Sidderbaum was adamant. First he told me, Mr. David, settle it for $10,000. You don't settle a frivolous case for $10,000. We had a wonderful U.S. magistrate who even took part in the deposition of the defendants. Okay? But this judge reversed it because Senator DeMotto's law firm was defending the case. And she ruled Mr. David hasn't shown an age discrimination. But in the trial transcript, which I happened to read this morning, says Mr. David is denied a jury trial. I was not denied a jury trial. I demanded, and we had an impaneled jurors. They heard arguments for 3 days from me. And when they were about to render a judgment based on the merit, Judge Sidderbaum stopped them, thanking them, saying that, jurors, thank you for coming. Mr. David has not proven an age discrimination case. She dismissed them. But that is not what is in the reported opinion, just came sort of a sudden. So, AT&T and their henchmen may be trying to depict me as a litigator, bringing frivolous claims. Appealing a court's decision is not a frivolous appeal. Discovery is to be granted to all litigants in every case, civil and criminal. I was stopped from receiving any discovery by the Kangaroo Court in Tampa or the Kangaroo Court in New York. You want to see the colloquy between me and Seibert. She says, Mr. David, no discovery. I will consider after I consider the motion for summary judgment. It's like saying, put the cart before the horse. You understand? You don't do that. She has to go back to law school. She went to the same law school Tilker went, St. John's in Queens. If she has to remain as a federal judge, she should be retrained. And so Judge Terrell William Hodges, who does not know the federal rules of civil procedure. He cannot issue a temporary order and still keep quiet. Folks, this is the American judicial system. Ladies and gentlemen of the jury, I want to thank you for listening to me so far. Now we are going to corrupt practices taking place in the U.S. Supreme Court itself. Pursuant to the court's October 2, 2017 order denying my motion to proceed in forma pauperis, which the court alleges is frivolous and malicious. The court stated in its said order, the Supreme Court, this is the website of the United States Supreme Court, case docket number, and I have my case here, docket search. It says in the Talakotu David, docket number 169624. When you hit that damn thing, it tells you here the case number, the docket on June 21, 2017, and proceedings and orders, petition for writ of mandamus, and a motion for leave to proceed in forma pauperis. Supplemental brief filed. And on October 2017, the Supreme Court says in its order, which is here, the motion for leave to proceed in forma pauperis is denied and the petition for writ of mandamus is dismissed. Why? No reason. Motion to proceed in forma pauperis is available both the civil and the criminal defendant. If the person is found to be not having sufficient resources, as in my case, I am living on a paltry social security pension. I submitted my papers to the court, they denied it. The reason, the court says, a petition for writ of mandamus denied, no basis. Why it is denied? Now, and they are saying Rule 39.8 of the Supreme Court rules. Now it continues, as the petitioner has repeatedly abused this court's process, the clerk is directed not to accept any further petitions in non-criminal matters from petitioner unless the docketing fee required by Rule 38A is paid and the petition is submitted in compliance with Rule 33.1. Okay? So the Supreme Court is saying, Mr. David, although we have not read your brief, based on what Melissa Blarlock told the court, it's a frivolous petition and malicious petition, so we don't want to grant him to proceed in forma pauperis. The Supreme Court says Mr. David can pay the money and submit the brief. Folks, on January 3rd, 2018, I obtained from ICICI Bank in Trivandrum, Kerala, India, a bank draft drawn on JP Morgan Chase Bank, NA, New York, on January 3, 2018, made payable to the clerk of the court. There is the draft. And I submitted 40 sets of my brief. Give me one, please. This is my brief to the US Supreme Court. These are all proof of delivery, sent by registered mail, costing me a fortune. This is one set of the brief with Exhibit A through T. Okay? This shows what transpired in the damn court system throughout. This is my brief, 40 cents. To print this, to obtain the exhibit tabs which are not even available locally, I have to order it from Mumbai, costing me more than 10,000 rupees, the exhibit tabs. Okay? When I sent these 40 briefs and this check, this bank draft, this woman, Melissa Blarlock, says, Mr. David, your petition is returned. Miss Melissa Blarlock, who has the sole monopoly in the Supreme Court, She sent the whole damn thing back to me. The draft and the briefs. Then she didn't send me all the brief. What she did was, what I did was, I put 37 copies of this brief in a box, because that is all the Indian postal authorities will allow you weight-wise to send. So I put 37 copies of this brief. That's the US Supreme Court rules. You got to submit 40 sets because you are a fee-paying customer. You are not asking or begging the court, allow me to submit my brief. What this woman does is, as soon as she gets that, she sends the whole thing back to me with a cover letter. This is her cover letter, which reads, Telco to David, my address, and in re Telco to David, petition number 15-9100. Folks, we are not talking 15-9100, that's all over. We submitted another brief, 169624. Now, she says, Dear Mr. David, the above entitled petition for extraordinary writ of mandamus was received on January 17, 2018. The papers are returned for the following reasons. You have to read what the woman says. Pursuant to the court's October 2000 order, the clerk has been directed to reject your petition in non-criminal matters unless you pay the docketing fee required by Rule 38 and submit your petition in compliance with the Rule 33. That is in the order. That's what I did. I sent her the damn fee. The $300 US dollar fee and 40 sets of this brief. Is this woman out of her range? Is a deranged woman sitting in the US Supreme Court? I'm doing exactly what is in the order. The order says, unless the docketing fee required by Rule 38 is paid and the petition is submitted in compliance with Rule 33(1). That is what I did. Folks, as soon as I got this check back with 4 sets of my brief, which you will see in this box, this is the box in which she sent me the 4 sets of the brief, okay? Cost the American taxpayer, I can't understand how much they paid. This is ripped off. It was sent to me by priority mail by this woman from the US Supreme Court. Okay, mail room of the US Supreme Court. She's telling me I have to comply with the damn rules, which I did. So this woman is either a nutcase or a corporation planted employee rendering political judgment and wrong advice to the US Supreme Court. Folks, I can't believe this woman has the sole monopoly. I tried to contact her boss, Jeff Atkinson. He will never answer the phone. He will never. I tried so many times, including last night, that is on Monday, March 5, 2018. Okay, they won't answer the phone. So whatever this slut is doing is accepted by the Supreme Court. As soon as I got the damn thing, including the check back to me, from this woman, who tells me the same thing which I did, I sent a letter to Chief Justice Roberts of the United States Supreme Court. I have no response. I tracked my mail when it was delivered. No response. I tried to call Justice Roberts Chambers. The operator won't connect me. They connected me only to the clerk of the court, which goes to ultimately to this woman, and her boss, Jeff Atkinson, won't answer the phone. I want to know why, when I complied with the court's rules in ditto, you can upload the court's latest rules, which is amended few days ago. I complied with the damn thing. Hey, I waited a few more days, then I'm getting another 14 sets of the brief. From this woman, this crazy Melissa Blarlock. No reason. Folks, yesterday I got another set of brief. The same 40 sets of brief I sent to them, one of which was dated January 18th by the Supreme Court. I sent that original brief with the draft, bank draft, to Justice Roberts. Folks, I don't understand what goes on behind the ivory towers of the corporations. Do the justices close their eyes when you attack the judicial system? Or is it a corrupt system designed to protect corporations? That's the question. The broader question I wanted to ask you people is, if the court, the appellate court, had no jurisdiction in Atlanta, Georgia, which is the 11th Circuit Court of Appeal, can a judgment so obtained through fraud, will it remain? Are we justifying fraud committed by the clerk of the court? Counsel for the defendants, Pete Silver, the good-looking guy, who is a well-experienced attorney licensed to practice before the U.S. Supreme Court, pretends he didn't read Judge Hodges' order. Okay? October 23, 1985 order, he didn't read it, which says dismiss the case without prejudice if Mr. David did not tender back the consideration to the employer. The Supreme Court says you don't have to do that. In an ADA Title VII case, you don't have to tender back the consideration. It can be set aside and adjusted at the end of the litigation. Folks, what Judge Reed, before he recused and resigned from the bench, was, he held a couple of conferences. One of them he held in his private courtroom, and the holding of that court was, Mr. David, the holding of Judge Hodges' order was, there is a triable issue of material facts remain in the case, a triable issue. When one judge says, when there is a triable issue of material facts exists in a case, how can a summary judgment be granted? Here we have different issues here. I'm sitting here in India. Temperature is nearly 90-95. So, my air conditioner doesn't work, seems. The question here is, folks, did the court below in Atlanta goof? Yes, they did, because the jurisdiction of the court was invoked based on a fraudulent document obtained from Donald Brown, who doctored it. The judge said dismiss the case without prejudice. The clerk altered and entered judgment on the merits, on the basis of which Pete Sinaba, who is authorized to practice law before the Supreme Court, and Arnie Conway, who is currently a judge in the U.S. Surveillance Court in Washington, D.C., and authorized to practice law before the Supreme Court, filed false papers before the 11th Circuit Court of Appeals. And the panel, predetermined by the defendants, by the same players, accept the case and affirm. Now I am questioning, challenging whether that court has jurisdiction, and if not, whether they have the authority to recall mandate. As I indicated before, of the three-judge panel, Robert Vance was bombed and murdered. Second judge, Clarence Allgood, took a gun and shot and killed himself. No judge in the appellate court will commit suicide unless the pressure from corporation so high. The players bargaining. So the judge has to go to either one side or the other. So he decided to take his life. Why a sitting federal judge in the United States Court of Appeal has to be bombed by Moody? They may be doing the same identical hangy-pangy there, every case that I investigated. Okay? People think in America the courts are the final authority and whatever they do is right. Folks, that's not the case in the United States of America. When it's a big mega corporation involved, they don't care a damn. Christine Anderson was one of the attorneys employed by the District Disciplinary Committee of the New York Bar. She blew the whistle. She blew the whistle saying the DDC, the District Disciplinary Committee, has double standards. One for the rich, one for the poor, one for the major corporations with the political clout, the other one without. She was disciplined, she was attacked by another attorney, her supervisor physically. The case is going on. I don't know, I didn't search it recently. What is going on there? There are a lot of lawyers complaining about the same damn system. Okay? I don't have to spend 36 years before these kangaroo courts in America to get an ounce of justice. This mafia corporation is so powerful economically and politically. They are the kingmakers. If you ask in the United States Court of Appeals, in any of the circuits, or in the district courts, whom they appoint as federal judges, this corporation is behind in touting lawyers of their choice. You understand? The name of the game is touting lawyers, planting them at key places so that those lawyers become judges. They render judgment based on politics. You understand? Folks, Supreme Court says in its order, Mr. David has filed so many cases against corporations. His case is similar to Martin. Let's go to Martin case. I went into the Supreme Court, the PACER system. They don't have Martin's case. I called the District of Columbia Court of Appeals. They don't have the damn thing. I called the U.S. Supreme Court, the clerk's office. They don't have it. Who has it? Do we know what are the facts of the cited case in Martin? Nobody knows. Everything is in secrecy. All that we see is Mr. Martin has filed so many cases. We don't know the facts of the first case to begin with. Is he a nut case? or a genuine appellant who is aggrieved like I am? We don't know. The published reports indicate Mr. Martin has allegedly filed so many cases. What about Mr. David? Folks, filing an appeal in a case is not committing frivolous appeals. For example, during the last 36 years, I was not given a dime. The discovery is the weapon with which you attack your adversary. No, Mr. David, you don't get no discovery. See the colloquy between me and Seibert in New York. She says, Mr. David, no discovery. I will consider it later. After she rendered a judgment, she will consider granting me a discovery. That's her philosophy. She's a federal judge, graduated from St. John's University, one of the best universities. I have no complaint with the university. She didn't go to Columbia or Yale or Harvard or any other one of the universities. Her knowledge is limited. How can a judge render a decision to a corporation, none of whose lawyers ever came to court? During the 7 years the case remained in Eastern District of New York. The corporation, as you see in the Charlie's Angels, managed everything under the table through the angels. Charlie speaks with his big money, the angels go and perform, and she gets the result, or the corporation gets the result. Understand the name of the game, folks? There should be bloody revolution in America sooner or later, because the court system is so corrupt, that I sit 7,000 miles away in India, and I feel sorry for my brethren in America, what they are facing. There will be bloody revolution in America sooner or later. I may not be alive then. As Martin Luther King once said, one day will come, the people will rise. I am not a revolutionary. I am an ordinary, simple American seeking an ounce of justice from these kangaroo courts. This is the book written by Chemerinsky. Federal Jurisdiction, that's the book. Federal Jurisdiction by Chemerinsky and Little Brown and Company published it. This book is the Bible. This book was written by Richard Epstein. Alan Farnsworth, who died 2005, Jeffrey Hazard, Sterling Professor of Law, Yale University, James C. Cryer, Earl Warren Delano Professor of Law, University of Michigan, and Bernard Wolfman, Harvard University, who died. This is the Bible. This is the jurisdictional Bible. This talks about, at length, this thick book, talks about whether the federal court has jurisdiction to hear my case or not. Here, folks, the federal jurisdiction was bought. How? Paying the clerk of the court, Donald Brown, money under the table so that he can change Judge Hodges' order into a dismissal on the merit. We can only appeal to the United States Court of Appeals if the case is decided finally on the merit. Was there any proceedings before this sucker judge, Hodges? No, folks. The only meeting I had with this guy was ordering me to appear before him for telling that he is the new judge. No further proceedings, no hearing, no trial, okay? Everything was done under the table in cahoot with this corporation. So from 1982 until 1985, until the judge recused and resigned in disgrace from the bench, and this case is assigned to this judge to continue the same dialogue. He decides the case based on a newly planted case law, subsequently planted case law, which itself was overthrown by the Supreme Court in Aubrey and Energy. Folks, this corporation can never, ever convince any juror in this country. Never, ever. You understand? It's all fraud. The district court is fraud. The Court of Appeals, not all of them, certain select Court of Appeals, they are corrupt judges. There are corrupt judges manning the Appellate Court, which are called the Circuit Court of Appeals. So, I'm not saying the entire 11th Circuit Court of Appeal judges are crooks. Only those crooked judges get the file or they get the case based on what the corporation insiders wanted. So the routing clerk is in cahoot, the judges are in cahoot, so as soon as a court gets the papers from any litigant, it goes to specially selected routing clerk. The routing clerk is the one with which they are dealing under the table. So the routing clerk goes to, or assign this case to a judge or a panel of judges of the defendant's choosing. Okay? The defendant's choosing which judge they want, pick and choose, guys. So he gets his money, pocket money, how many lakhs or how many thousands he gets it, we don't know. Why a case from district court to the appellate court goes to the same panel of judges each time? Especially when Judge Edmondson ceased himself to be an active judge of the court as from 2012. So, the case goes to only Edmondson. There are so many judges in the United States Court of Appeal for the 11th Circuit. It goes to Judge Edmondson and Stanley Marcus, whose decision was overthrown by the same court when he was sitting as a judge in the Miami District Court in Florida. Okay? Now when you go to the US Supreme Court, this woman, Melissa Bladdock, she is the only case analyst getting my file. Folks, why this is going with the mathematical precision from one person to the other without any legal basis? Is Melissa Bladdock the only clerk, only legal analyst in the US Supreme Court? What about Mr. Atkinson? Why he doesn't talk? Because they know what I am going to say to them is the truth. They don't want to face the truth. The court should investigate if the enforcement agencies and the whistleblower should investigate, and the FBI, why all my appeals go to this woman only. Am I raising a frivolous matter? Am I raising a malicious issue? What the judges did is fact. It's on record. It's all in the federal records. A taped discussion with the judge, Judge Reed. No federal judge will call a pro se litigant unless he knows what he is doing is corrupt. Okay? After Judge Reed resigned, he went to join a law firm, Cantor, Lourdes, whatever it is, in Orlando, Florida, where AT&T had 1,500 relocating employees, real estate cases. So his firm got all these cases. It's a kickback. You understand? There is no investigation. The issue, folks, as I indicated to you, was whether the United States Court of Appeal for the 11th Circuit had jurisdiction or not. If the court had no jurisdiction, they should recall mandate. Furthermore, the same judge who issued the order upon which the clerk altered and then the defendants moved to the United States Court of Appeal, the judge says, oh look guys, we made a mistake in our order. The clerk made an order. He issues in 1991 an amended order. So what is the effect of this amended order? Nobody knows. If the court has no authority to hear the case, it heard and decided, Supreme Court affirmed. Now I am telling the court, hey, look, this court had no jurisdiction to start with. How can they hear the case and decide? No answer. I have cited so many case laws from the Supreme Court itself, Supreme Court of the United States, which says if the court lacks jurisdiction, its judgment is a nullity. Nullity. Okay? This threat, Melissa Bladdock, tells the justices, his case is frivolous, malicious. He attacked judges. Am I going to sit idle and not attack them when they do hangy-pangy under the table? Folks, you American people, you should rise. You can't put up and shut up this shit all the time. The courts have limited authority, which was created under the Constitution by the Congress. The court cannot remain as a partisan interpreter of the laws for the corporations, the court of the corporations. I pray the American system of government, its judiciary, will rise to the occasion. Okay? If not, there will be loss of the jungle. People will be killing each other. Corporations will be attacked and bombed, and whatever people do stupid things, they will continue to do so. And this will multiply with the passage of time. I hope whether my $300 check will come back to me from the Supreme Court, where it is sent to Chief Justice Roberts. I tried to find out what happened to my check. No response. The switchboard operator won't connect me to the chambers or to a person I can speak to in the US Supreme Court. It goes to the clerk of the court. He says, oh, Mr. David, no, yes. I said, sir, read Rule 30D. The court's order dated October 2. So the clerk, whichever clerk answers, oh, they say yeah, then they say yes. What yeah and yes? I paid the $300 filing fee and I prepared 40 sets of this damn brief. Folks, I hope the American Supreme Court will rise. The enforcement agencies, including the FBI, will do their job. If they can tried to attempt to control President Donald Trump, who was elected pursuant to the rules, and the CNN keep bugging him every day with the new discoveries. What he did, how many people left the White House. That's the kind of dirty politics going on in America. Dawson, Ralph Curtis Dawson, who is the chairman of the Democratic Party's Rules Committee, was ordered to be investigated by a 5-judge panel of the Appellate Division Supreme Court, State of New York. Did they conduct an investigation against this sucker? No, sir. He's untouchable. He's above the law. This black monkey is above the law. So he can file false papers. He can file false papers and get away. What's the false papers here? Tilker's affidavit. Can Tilker file an affidavit in violation of the canons of ethics, who is an attorney, and his affidavit was completely perjured and false? Because at the time when I signed the release in Detroit, Michigan on August 25, 1981, Tilker was only a child of 2 years old, still in his diapers. So, the Supreme Court refused to conduct investigation, not the Supreme Court, the disciplinary committee of the New York Bar. They sent it to the second Judicial Department saying there is a conflict of interest because Mr. Dawson is a member of the disciplinary committee, and the second Judicial Department in Brooklyn, New York refused to conduct the investigation because he's a big fish. This black monkey is a big fish. He Columbia School Law graduate and the chairman of the Democratic Party's Rules Committee. That's the kind of justice system we have in America. Folks, the system of justice stinks. Its colorless odor can be felt around the globe. Folks, I want you gentlemen and ladies, listen to what I'm saying. I'm a Christian. I may pass by maybe within few years, but the message that I'm giving to you should linger on my next generations. Like Martin Luther said, I am professing, I am preaching, and I am telling the world what is going on in the judicial system in America. Corruption mill at its full swing. Those who wanted to listen to me, get the facts, additional materials, they can send me an email which is trdavid2009@gmail.com. They can also call me on my toll-free number from the United States. Doesn't cost them a dime. My number is 1631, which is my Amityville number, 841-6222. Hi there. Good morning, good afternoon, good night, whatever the case may be, depending upon which part of the world you are listening to. This is a continuation of my prior recording. It's too hot here. I can't sit here with the air conditioner on, still I'm sweating. So I took my jacket off. You can understand me, what I'm talking about. I'm going to talk to you about the corruption within the United States Supreme Court. Corruption within the United States Supreme Court. You may think the Supreme Court is a honorable, nice place where the 9 justices rendered justice accordance with the law. That is in theory. What is happening in the United States Supreme Court, folks, we have 9 justices in the American Supreme Court, Neil Gorsuch being the last one, who is 51 years old, appointed recently by President Donald Trump. The other justices are Ruth Bader Ginsburg. She is now 85. She was born on March 15, 1933. Next justice, Antonin Scalia, who is 82, born on March 11, 1936. Anthony Kennedy, 82, born on July 23, 1936. Clarence Thomas, 80 years old, June 23, 1948 was his date of birth. Samuel Alito, April 1, 1950, now 68 years old. And Sonia Sotomayor, born on June 25, 1954, who is 64. Chief Justice John Roberts, born on January 27, 1955, who is 63. And Elena Kagan, 58, born on April 28, 1960. So, folks, in India, judges retire at the age of 65. In America, the judges come to occupy when they are much older. Whether they have the brightness, the intelligence, we don't know. I am not a psychiatrist, I am not a doctor, so I can't tell. Whatever they are producing are what they get from their law clerks. They broadly address the issues, provided the law clerk assigned to them correctly tell them the facts, which is not what is happening in this case. In this case, gentlemen, on the case number 16-9624, in re Thalakotur R. David. The court denying my motion to proceed in forma pauperis held on October 2, 2017 stated as follows. The motion for leave to proceed in forma pauperis is denied and the petition for writ of mandamus dismissed. See Rule 39.8. As the petitioner has repeatedly abused this court's process, the clerk is directed not to accept any further proceedings in non-criminal matters from petitioner unless the docketing fee required by the Rule 38 is paid and the petition is submitted in compliance with Rule 33.1. That's what the court says. Mr. David cannot proceed without paying the court fee because he is, according to them, I am filing frivolous petitions. That is the decision of the Supreme Court without going into the merit of the case. Okay? The court doesn't go into the merit. What the court is told by their law clerk, in this case, Melissa Blarlock. She is the only law clerk involved in my case during the last 10 years. The Supreme Court rules say each term the Supreme Court selects qualified, bright students from well-known universities. But that is only in theory. In practice, what happens is the hand-picked law clerks who are on the payrolls of the corporations get the case. Now, this woman, this crazy bitch, young Blarlock, returned my papers. There are, you see, 40 briefs here, 40 sets of briefs. She sent that brief back to me in one package containing 4 in one box. Along with my draft for $300. That's the fee I paid to the US Supreme Court to accept my case, assign a docket number, and proceed ahead with filing the papers. She doesn't do it. She sent it to me one box, the next day or maybe a few days later, 14 sets. Another day, another 14 sets. And the remainder came to me on March 6 at 2018 at about 3 o'clock. This woman is returning this. Now, her reasons, as stated in her letter, dated January 17, 2018, addressed to me. She says she is citing their case number 15-9100, which was dismissed long time ago for the same reason. Now, my next brief in respect of case number 9624 of 2016 is a different animal. Okay? She doesn't cite that case in her letter. She's citing a previous case filed and dismissed in 2016. Now, in the body of the letter, she says, pursuant to the court's order of October 2, 2017, the clerk has been directed to reject your petitions in non-criminal matters unless you pay the docketing fee required by Rule 38 and submit your petition in compliance with Rule 33, which is exactly what I did. I obtained a $300 draft made payable to the clerk of the US Supreme Court, drawn on a New York bank, Chase Manhattan Bank, and submitted these 40 sets of brief. This stupid woman, either she is a maniac or she is a paid corporation plant working in the US Supreme Court, she is sending it back. Not in one box, in 4 sets of boxes, costing the American damn taxpayer more than the filing fee, which I asked the court to waive. Folks, this woman is also advising the US Supreme Court justices who don't read all the 10,000 briefs coming before them. She goes through that and then she makes some notations and tells them, hey, this case is frivolous, malicious. Okay? Now let's get to that fact of the case. Ladies and gentlemen, when a United States Court of Appeal has no jurisdiction to entertain an appeal, which is an interlocutory order of the Tamba District Court, the court has no jurisdiction. But how they manage the defendants is bribing the clerk of the court, Donald Brown, who was himself fired by the Tampa District Court for doing a sort of hanky-panky. They found him incompetent. So what he did was, the judge at Tampa, who is another plant by the corporation, because the case was originally with Judge Reed, who was going and meeting AT&T lawyer, Miss Conway, at her home, and she was meeting him at his home. He called me on the phone, admitted this in a taped telephone conversation consented by the judge. Then I notified the FBI and the former Chief Justice Warren Burger. He resigns. He resigns from the bench in disgrace. The courts don't want why he resigned all of a sudden. They don't tell Mr. David's complaint was the cause for his abrupt resignation and recusal from the case. Now he chooses which judge should have the case. You understand the deals here? I file a case in Orlando, Florida. They have 6 judges in that court. If one dies, become ill, resigns, whatever it is, the case should have been reassigned to another judge in that court, which defendants don't want because they know the psychology, the history of every judge. They are honest, thorough judges, good judges, so they don't want this case to go to one of the judges, other remaining 5 judges in that court. They want to transfer this case from Orlando to Tampa before a judge of their choosing. Did this judge, Terrell William Hodges, did he conduct any proceedings? The issue before the court, the sole issue, was the validity or otherwise of a release obtained from me under duress, coercion, through fraud. The first judge, before he is being bribed, he ruled against them. He said he will conduct an evidentiary hearing pursuant to the standard set by the U.S. Supreme Court in Alexander versus Denver Gardner, which the defendants don't want it. They try to fish for 3 days to find out whether they can get something damaging from me and from my former wife. They questioned me for 3 days, they couldn't get a damn. Okay, they couldn't get a damn. So, the plan was transfer the case to another judge of their choice, and Judge Hodges, without allowing me to conduct any discovery whatsoever, without holding any meeting, any status conference, without any notice and hearing, abruptly issues an order based on a timely hatched case law planted by the same corporation, AT&T and Michigan Bell in Michigan. Courts, folks, in America, 2 types of courts if you don't know. One is a federal court, one is a state court. The decision of the federal court prevails, not the state court. But here, the tail is wagging the dog. So the state court is telling this guy who was dismissed by AT&T, McDonald, must refund the money to the employer. So the state court says Mr. McDonald must refund the money. So the federal judge, instead of questioning that, he says, yes, that's right, Mr. David should refund the money to the employer. Folks, that decision was overturned by the U.S. Supreme Court in Aubrey versus Antonergy. Decided later on. So now the question here, the legal question for the consideration is the Bible, the United States federal practice, the federal rules of federal jurisdiction. As I told you, this is the Bible, written by 5 professors, which is what the U.S. Supreme Court uses. So, the clerk alters the judge's order from a dismissal without prejudice into a dismissal on the merits. You understand? Clerk pays some money, so he does what he was told. He enters a judgment. You see the copy of the entry of judgment. Wherein he says the case is dismissed on the merits. Was it on the merits? Is Judge Hodges' order, was it on the merits? Or without prejudice, which is an interlocutory order? Folks, this is a fraud. Okay? They know, all the players, they know they are in cahoots with each other. Pete Cinema, who was then working for the law firm of Carlton Field, Emmanuel, Cutler and Smith, lied. Annie Conway, working for the same firm, who was hired timely to get judge involved in this case, she files affidavit, jurisdictional statement. You will see that. And the in-house counsels of each of the defendants, Tony House and Anthony Christopher, they filed false papers telling the appellate court it has jurisdiction. Does it have jurisdiction, folks? No. The appellate court can only consider a final judgment rendered on the merits, which means there should be hearing, there should be trial, there should be discoveries, there should be witnesses heard before a jury as demanded in my complaint. This is the copy of my demand for complaint, which I am going to show to you in a second. So, there is no jury trial, no hearing, no discovery, nothing, and this puppet judge, William Terrell Hodges, renders a judgment based on a case law timely hatched by the same defendants. See the name of the game. My case filed in 82 is kept in abeyance until 1985-86 and obtain an order from a state court and ask the federal court to apply the state court law. What a joke. I didn't go to Harvard or Yale or Columbia. I went to a small town law school in capital of India, Delhi, in 1966, 67, 68. So I'm not a Harvard law professor. I'm not a Columbia School law graduate like many of the justices or any of the lawyers here. But I'm telling the court what the law is, what the jurisdiction, whether the court has jurisdiction. Okay? This is the Bible. This is the Bible. But they say, they don't say, this woman, Melissa Blaylock, says, Mr. David has not raised any important issue. It's only a routine thing. It's frivolous. His case is frivolous. People, you around the globe, ask yourself, is my case against this company and against the Court of Appeal for the 11th Circuit, is it a frivolous case? It's a fraud, corruption. Okay? Lawyers filing false papers, clerk altering the order of the judge, and I am asking the Court of Appeals to overturn. Oh folks, the name of the game is the panel, the original panel in 1986. Judge Vance was bombed and murdered, he's gone. Next judge took a gun and shot and killed himself, he's gone. Because they are all sick and getting tired, the corporations be higgling and bargaining, so judges don't know what to do. So this judge took a gun and killed. They don't want the people to know what's going on. It's a safe, top secret. You understand? I'm not a crazy man, yes, you see me. I'm not crazy, I'm telling the law. So this crazy woman, Melissa Blaylock, sent me all these papers back, telling me the same thing as in the order. That is what I did. I submitted my 40 sets of brief, legal brief. Along with my bank draft. The rules the Supreme Court published is the latest one. Supreme Court of the United States adopted September 27, effective November 13, 2017. That's the latest rule. Now, I'm going by the rules in its letter and spirit. Rule 33 says there should be two ways of filing. One is a booklet format, or the other one 8.5 by 11-inch paper format. There are two rules, two formats. One is a little book like this, printed. You have to get it printed and everything. The other one is the standard 8 by 11, as I did here. Okay, 8.5 by 11. Now, all the rules are here, which says the front cover, the petition, the details here, my address, my telephone number. The questions. Then it goes to the questions presented. Not like anywhere else, US Supreme Court has special rules. So they should show on page 2 what are the questions for review. The questions, one of the questions I raised in my appeal was, if the United States Court of Appeals for the 11th Circuit lacked jurisdiction in the first place to accept and affirm an interlocutory order of the Tampa District Court, which was altered by the clerk of the court on his own, and entered a judgment as on the merits, as opposed to the court's order to dismiss the case without prejudice, and the defendant's counsel filed a false jurisdictional statement alleging the case is appealable pursuant to 28 U.S.C. 1291, and the appellate court accepted jurisdiction in error. Not knowing that it lacked jurisdiction, should this court have the authority and the jurisdiction to review the same, especially when the Tampa District Court subsequently amended its prior judgment as a dismissal without prejudice, some 5 years later on, after the Supreme Court denied certiorari in 1986. So what happened to us? The first appeal was denied by the Supreme Court. They didn't know. I didn't know at that time the court had jurisdiction or not. It's a fraud. When I was working in another law firm in New York, I came to know if the court's dismissal is without prejudice, it is an interlocutory order, unappealable, which is the issue I'm raising. The second question I raised in my questions presented for review was, did the Tampa court's refusal to conduct further proceedings after it ordered the clerk to dismiss the case as without prejudice if petitioner did not tender back the consideration, call for direct review by this court, especially when the Supreme Court has expressly rejected the tender back defense in Aubrey versus Antonelli. So there are two issues. Whether the court has jurisdiction to begin with, okay, which they don't want to address, and what is the role the district judge should have done after it issued an interlocutory order. He's keeping quiet. Folks, these are not silly questions. Now this woman apparently told the justices, as can be inferred from the court's decision, that my case is malicious. What does malicious mean? Malicious means we are making a story based on malice. Do I have any malice against the judge or judges? No. The judge, first judge, John Reed Jr., colluded with the defendant's counsel. He was going to that woman's home. She was meeting him in his home. They were meeting in other places as if they are playmates. You understand, folks? So, The question here is not that I am making a malicious allegation. The second allegation I made is against the second judge, Judge Hodges. Did he conduct the proceedings pursuant to the standard laid down by the first judge? No, he doesn't want it to conduct an evidentiary hearing to determine whether the release is valid or not. That's the sole issue before the court. Did Mr. David resign his job, high-paying job, and quit and went home to enjoy life before a swimming pool? That's the question. Jurists don't want to hear this case. AT&T knows they have no leg to stand, so they have to cling to this woman who is a broker, Annie Conway. Now, for her efforts to do the hanky-panky, she was immediately made a judge in the same court. Annie Conway was made from a local lawyer to a judge in the same court. Then she was promoted as a chief judge. You understand? And when I start putting my David versus AT&T Part 7 documentary, they immediately transferred her from the Orlando District Court to the US government surveillance court to order the execution of innocent people who are considered to be enemies. We don't know, I don't believe, I don't trust a second the United States courts or the government. Are they telling the truth or bluffing the public? Folks, I attacked these corrupt judges and the woman judge in New York who, based on a 2-year-old child's affidavit, he's an attorney today, so he was talking about what happened in 1981 when he was 2 years old. He says he has personal knowledge about David executing a release. How can a 2-year-old child born on May 5, 1979 know what I did on August 25, 1981 in New York, in Florida, in Detroit? It's a perjury, a lawyer committing perjury. And who are the partners in that crime is the chairman of the Democratic Party's Rules Committee, Ralph Curtis Dawson, the black monkey, who graduated from Columbia and Harvard or Yale. Okay? So if he tells the guy, Brian, file an affidavit, we can manage, or Judge Seibert, or we are in cahoots with her. Okay? So this bitch, Judge Seibert, who is a puppet of the corporation, grants a summary judgment based on the 2-year-old person's affidavit, sworn affidavit. Folks, the corruption mill goes in a clockwise arithmetical way. That goes to a panel of the defendant's choice. Judge John Walker, Rina Raggi, Judge Rakoff. I've shown them their pictures in my last documentary. They affirm. What the fuck they are affirming? 2-year Tilker did right, and so she's quoting him, and she's granting a summary judgment in ADA and Title VII case. Folks, it's a joke. The biggest joke the American courts can have. They will never ever face me in a proper court of law, this corporation. Folks, now they are saying another story. You have to hear the story, folks. I didn't have the time or occasion or the space to write the whole story. Respond back to the court's position. I'm a frivolous, I'm a litigator. But Mr. David has proceeded. There is a petition writ of mandamus denied, as the petitioner has repeatedly abused the court's process. The clerk is directed not to accept any further petitions. Okay? If you are a criminal, it says except in non-criminal matters. Okay? Now, unless I pay the fee. Now, I sued after I was illegally dismissed. I went to a competitive exam before the city of Miami. I got a score of 98.6 out of 100. The discoveries showed the city hired even people with a 60 score. I am at the top, 98.8 and 98.6 score. The city refused to hire. I sued them, the city of Miami, for failure to hire me. Judge Lawrence King, one of the finest judges I ever seen in my life, he told the city, hey guys, find him a job, he's qualified by your own standard testing. They don't want to hire me. So what the city did was, like the corporations do, they simply changed the judge. Judge Stanley Marcus, Judge Lawrence King and Judge Palermo, he's another finest judges in the magistrates in the US courts. I don't know what happened to them, I didn't search. I think Judge King might have been dead, now he's too old at the time. So, they assigned this case to this newly appointed Judge Stanley Marcus, who was a district judge, who was then appointed on political basis. So the case goes to Stanley Marcus. I sent a complaint to senators and congressmen to inquire, to find out what the hell going on in the courts. So Judge Stanley Marcus issues me an order directing me to come to the court for a settlement conference. You don't file a frivolous claim and the judge will ask you to come for a settlement conference. I was in India at that time. I flew into London. From there I had to fly to Miami. So when I reached London, I didn't get a flight. So I called the court and they said, Mr. David, you can come after 1 month, there's no problem. In the meantime, City of Miami files a motion for summary judgment. That's a tactic everywhere. Motion for summary judgment means the case should be dismissed only purely on paper. Judge Stanley Marcus immediately grants the city a summary judgment. There is no factual basis. He grants it as a politician rendering a service. But luckily for me, I appealed to the 11th Circuit then, and a panel of 3 judges reversed Judge Marcus' order. The city was thereupon forced to settle the case for a sum of $16,224. That's a copy of the City of Miami, Florida. The case dated 7/13/1989. Bank issued Southeast Bank, NA, Miami, Florida. That's the check. You don't settle a frivolous case against a city for failure to hire. So you can understand how meritorious my claim was. But this lot says, Mr. David has filed so many frivolous claims, repeatedly abused the court's process. Folks, I appeal every stupid decision these concurrent courts have made. Motion for summary judgment, denial of discovery, denial of jury trial. These are my rights, my constitutionally guaranteed rights to appeal the arbitrary and capricious decision of judges. That's not frivolous. Now, the second case, all happened during the same period. I was unemployed, and once you were fired by an employer, a US employer, and you fight against them, what they do is blacklist you. Those who have been fired from their jobs, and if you fight in the courts, you can never get a job. Because in America, employer A will call employer B and ask how was this guy. They will say, oh, he's a pain in the butt, so don't appoint him. So nobody will reject, now nobody will accept. Folks, that's the name of the game. Now, I went to work for a CPA firm called Appellate, and Company, a Jewish firm. And I was hired through an employment agency, and the employer had to pay them 6 months' salary for getting me a qualified person to do the job. I had a young colleague, a young 22-year-old woman in my same room I am sitting. She won't do any work, absolutely no work. She is titled as secretary. What she does is, she goes to the rooms of select partners to provide mental satisfaction or sexual satisfaction, and to certain select accountants. She will pass on her work to me. I don't want to name her, I can't even remember her name now. Now, when I told her, Miss, you have to do your job, don't pass it on to me, I have got my own work. She went to one of the partners, started crying. So next day, I was laid off from my job. Laid off. I was getting more than $1,000 a week at that time in I can't remember the year. Plus overtime, I can't handle it because there are 30, 40 CPAs in the office. They have to prepare a report and everything. This girl will spend 2 hours lunchtime, 1 hour coffee break, then goes smoking. She's a chain smoker. So I was laid off. Not a conflict with this woman. I told her to do her job, don't give it to me. That's not a confrontation with a co-worker. Now, the next day, after laying me off, the employer hires 2 young girls. Young girls. What is their purpose? Telling me I'm laid off. They write to the Department of Labor saying that Mr. David is laid off, so giving me some employment benefits. And the same employer hires the very next day. The very next day. Friday I was let go, and on Monday they bring in 2 young chicks. Folks, I filed a lawsuit against them. I had discovery. During my discovery, one of the best magistrates took part during my questioning the city, my questioning the employer. Okay? The judge won't conduct a trial. Judge is Miriam Siderbaum. She refused to conduct a discovery. She refused to conduct a hearing and a trial. And I kept calling her secretary or deputy. And then judge says, Mr. David, settle the damn case for $10,000. I spent more than 20 to get the transcript, the court proceedings and everything. The judge says, settle it for Mr. David $10,000. Do you think a federal judge in her right mind will tell me to settle a frivolous claim for $10,000? I said, I don't want the money, Your Honor. I want to go for a trial, jury trial. First she resisted. Then finally, we selected jurors. 3 days the jurors heard my arguments. You have to understand what is going on, folks, here. This woman is telling the Supreme Court, Mr. David has filed abuse the court's process. And my case is similar to Martin versus District of Columbia Court of Appeal 506 US 1. Okay? Are my claims frivolous, malicious? Folks, I didn't have an opportunity to respond in my brief about this because that is not the issue before the court. The issue before the court was as to whether US Court of Appeal has jurisdiction or not, and what the judge should have done after entering a dismissal without prejudice. The new judge in Orlando, in Tampa, Mr. whatever his name, I can't remember, He says, Mr. David, this case was dismissed long time ago, we can't do anything. The court's order says, dismiss the case without prejudice. So, they don't know what they are doing. Judge Edmondson refused to take part in the proceedings. He refused to submit my papers to an en banc court. He refused to submit my papers to a 3-judge panel pursuant to the Federal Rules of Appeal procedure. He rules everything by himself. It goes to the clerk of the court. It goes to the assigned routing clerk. That's the scheme. Routing clerk, under the scheme, he will say, send it only to this judge. Because if it goes to another panel of judges, they know what I'm talking about. They will rule differently. Does this court, the 11th Circuit Court of Appeal, have jurisdiction to refer the matter to a judge who is no longer an active judge? Judge J.R. Edmondson ceased to be a judge of the 11th Circuit as from 2012. How can he rule this case in 2017? Folks, the whole thing is a fraud. Fraud, fraud, fraud. And there's a cover-up. And the poor justices, 9 of them, they don't read the damn thing. They don't have the time to read 10,000 cases. You understand? So, the ultimate resting place for every brief like this, filed by tens and thousands of people in America, end up in the waste paper basket. Oh, by the way, I tried to research the case they are citing, Martin versus District of Columbia Court of Appeals. I called the DC Circuit to get the facts of the case. They don't have it. The United States Court of Appeal, the District Court of Appeal, the DC Circuit, they don't have it. I called the PACER system, they don't have it. I called the Library of Congress, they don't have it. And I called the Supreme Court a couple of times and they referred me to another person and he's keeping quiet. Okay? So, you gentlemen, ladies, decide as jurors what is happening in the United States Court of Appeals. I'm not the only one complaining about what is happening. There is every kind of scheme going on. For example, Miss Christine Anderson, she was one of the panel of body of the Bar Council. She complained she blew the whistle, told the New York State Supreme Court and others what is going on. How mega corporation lawyers get away with murder, literally with murder. Okay? Dear friends in America, lawyers, judges, all over the world, I want you to listen, watch this video to understand what goes on in American politics, in the American Supreme Court, the name of the game. For the last 36 long years, I fought to have a hearing and a trial before a judge, before a jury, pursuant to the rules. This mafia corporation known as AT&T and its subsidiary Michigan Bell then, they won't allow me. There are deals under the table, as you can see from the prior proceedings. I want you to cast your vote after listening to this video. Folks, it is time for you, the world community, the jurists, the lawyers, law professors, law students, to understand the gimmicks going on in this case during the last 36 years when the defendants have no defense whatsoever. So, please cast your vote after listening to me, this video recording, which is David versus AT&T Part 8, and a prior video, which is more than 2 hours long, it will give any researcher, any person, either from the Department of Justice, FBI, or any of the enforcement agencies or the bar councils in America, to understand what goes on. Why I can't get a jury trial or a trial at all. Why summary judgment when there are tribal issues? That's the question. Now this bitch, Melissa Blalock, she had no business to send my money back, which I forwarded to Chief Justice Roberts with a cover letter to investigate, with a stamped copy of my brief, which was dated January 18, 2018. Why the clerk of the court don't accept my brief and my money? What is her explanation? Okay, she, as I read to you, she says in her letter dated January 17, 2018, she states, pursuant to the court's order of October 2, the clerk has been directed to reject your petition in non-criminal matters unless you pay the docket fee required by Rule 38 and submit your petition in compliance with Rule 33, which is exactly what I did. Folks, I paid the money, I submit the brief, she's shipping it back. Is she a lunatic? Or is she a corporate plant getting confused? Think about it. What the Supreme Court is doing. You can contact nobody there. All that you get is a call to an operator. Operator will forward the call to this same bitch, Melissa Blalock. When I ask I want to speak to a supervisor, they won't connect me. What is going on here? The FBI should investigate. Every law enforcement agency in the United States must investigate what is going on here. Whom should I approach? I have the right to get remedies to my grievances. I have the right to get my ERISA benefits, which is guaranteed. Okay? All these are shrouded in mystery. I can't even get who this Melissa Blalock is, because I tried to Google it, and there are so many of them with the same name. Okay? So, I will ask respectfully, you ladies and gentlemen, to cast your vote. You can contact me anytime by email. My email address trdavid2009@gmail.com. My toll-free phone from the United States is area code 631-841-6222. Ladies and gentlemen, once again, I want to thank you for listening to me so far. We were about to close this documentary. We were doing some editing work when all of a sudden we received on March 11, 2018, a letter dated February 16, 2018, signed by Jeffrey Atkins. Who is the supervisor to Melissa Blalock. He writes in his letter, "Dear Mr. David, in reply to your letter or submission referred to this office by the Chief Justice on February 16, 2018, I regret to inform you the court is unable to assist you in the matter you present. On October 2, 2017, the court dismissed the petition for writ of mandamus in case number 16-9624. This case is considered closed in this court. The papers are returned herewith. Your check for $300 also returned herewith. Sincerely, Scott S. Harris, clerk, by Jeffrey Atkinson." His phone number is here. Now, they have also returned the letter that I sent to Chief Justice Roberts of the US Supreme Court. You will see here the letter signed by the clerk, Office of the Clerk, Supreme Court, on February 16, 2018. What I asked the US Supreme Court, Chief Justice Roberts, is the court's order dated October 2nd in case number 16-1964 in case number 1684 titled In Re Talakotura David Petitioner and case number so and so. In that case, the court ordered per curiam, which I am reading again, which you have seen before, the motion for leave to proceed in forma pauperis is denied and the petition for writ of mandamus dismissed. See Rule 39.8, period. As the petitioner has repeatedly abused this court's process, the clerk is directed not to accept any further petitions in non-criminal matters from petitioner unless docketing fee required by Rule 38 is paid and the petition is submitted in compliance with Rule 33.1. So, I don't understand what the clerks say telling me, Melissa Bladdock and Jeffrey Atkinson. Chief Justice Roberts can read its court's own order, which says, unless the docketing fee required by Rule 38 is paid and the petition is submitted in compliance with Rule 33.1. I don't understand, folks. I am not an expert. It's a simple English. Any idiot can understand what it says. You pay the fee, you submit the fee, docketing fee required of Rule 38, and the petition is submitted, which is exactly what I have done. Folks, you gentlemen, ladies, you should understand what is going on. This is politics. The clerk playing the game. The major players who are supposed to interpret and apply the laws, they keep quiet. I write to Chief Justice saying this is exactly what I have done. So he doesn't take any action. He doesn't read the court's own orders and send it to another clerk. The other clerk transmits the same shit back like Melissa did. Folks, this is a political system. I don't think it's a judicial system. In a judiciary, in a proper judiciary, they interpret and apply the laws as passed by the Congress. Here, the American judiciary doesn't want to do it. It's a political game. You understand? President Trump was elected pursuant to the rules by the majority of the people, majority of the electorate. Now they are playing games with him, with the President of the United States. I'm a little guy born in a small village in Kerala, India. I don't have the time. 36 years' time is more than enough for any United States judges, courts, to grant me discovery. What is the problem with the discovery? What is the problem with the trial, bench trial? What is the problem with the jury trial? Folks, the issue I raised, and which I explained in my brief, is of paramount public importance. It is not a trivial issue whether the court had jurisdiction or not. That's a crucial issue. You understand? So folks, think it over, what is happening in America. I never ever think for a moment this is the United States of America whose courts interpreting and applying the laws. What is the remedy I have? Do I have to do stupid things like others did? I'm a peace-loving person. I was born in the country of Mahatma Gandhi, but I can make my pen mightier than the sword. I hope you will understand with me. Hope you will send me your comments. I will appreciate. And I ask the world community to make the system, to tell the United States congressmen and senators and the president what's going on in the courts here. Thank you, ladies and gentlemen. I want to thank you once again. Thank you, thank you, thank you.